I'm Richard Wee from the bar. My question, two questions, direct straight to Tan Sri. First question, in your view, do you think Matthias Cheng was correctly charged under Sosma? That's the first question, because he's a solicitor. And I'm speaking from as a lawyer. We do work every day. We defend our clients every day. We go to court. Amir and I, we do criminal work. We go to court every day. How can a lawyer be charged for representing his client? So my first question is that. And my second question, I'm sorry, I'm going to break rule. I'm actually going to ask something outside Sosma. I really would like to know, how are you? I really would like to know, how are you?
I will not give you my views at all, because the matter is before the courts. And as a matter of policy, I do not make my views on that. Okay. On the other issue, how I am, I'm okay. I'm on dialysis 3 times a week. I still do read. I still do work, and I'm not in the office. I do work like looking after my grandchildren. Oh yes, and sometimes entertaining my good friends around here. Or rather, they were entertaining me, and some other friends too. That's it. But well, I am functioning very well. I have no issues. But bear this in mind: when I was sitting there in the office too, I was already on dialysis, and I think I had some dealings with your president and past presidents even when I was in dialysis. So I'm okay. You see me? I'm all right. Thank you.
My name is Hazwani, short Nani from Sina Project. So I would like to shoot a question to Gani. What is your personal views regarding ISA, EO and various related laws designated for detention without trial? Do you believe that the acts, including SOSMA, is just and fair laws, or were you just doing your job, aka executing laws that was enforced?
I act like any other ordinary lawyers. In the capacity of an AG, I give advice, just like any other lawyers, and we take instructions from the client. Okay? And it is your parliament that pass your laws. Bear this in mind. I'm not responsible for electing your MPs. You are. Okay, whatever it is, but that is the case. You have your MPs. The laws are there. Your MPs voted for it. But if you ask me whether it's unfair or not, I will say this to you again: SOSMA is needed. I don't go further than that. However, it is how you interpret and implement it. I think that is the question. There may also be flaws in it. I'm fine. But as we all experience, laws will be amended to take care of these things along the way. Thank you.
Hi everyone, my name is Louis. So I can build up on Tan Sri's answer. My question is to Amza and perhaps to Mr. Stephen. You mentioned that there's about 150 people that were charged with SOSMA till this date. Do you agree that some of them indeed are involved in terrorism? And if that's the case, does that justify that we do need SOSMA to counter these terrorists? And if we do say that SOSMA is unconstitutional, and therefore we do away with SOSMA, do we have currently existing laws enough to tackle these issues? Thank you.
Dealing with various threats to the state, to the public, to the federation. So we have those substantive laws. So the question is whether or not the procedural laws, the evidentiary laws, are sufficient in order to try them in the court of law. To answer that question, I'm on the view that we have our Criminal Procedure Code. We have our Evidence Act 1950, which governs matters pertaining to investigation, trial process, and then appeal process as well. So we have all those laws in existence. So if you ask me from my point of view, yes, we have adequate laws to deal with those kind of scenarios. But under Article 149, as I think both Tan Sri AG and myself had mentioned, the Federal Constitution allows the Parliament to legislate special laws in order to deal with special situation. And when that special situation deals with threats to the Federation, whereby certain fundamental rights can be suspended in order to deal with that, or to arrest with that particular danger or situation. So even without SOSMA, those who have been arrested for security offences can be tried in the court of law. We have CPC, we have the Evidence Act. So there is nothing, so we cannot say that just because we do not have SOSMA, therefore they will not be brought to justice. That's not the scenario. It's just that having these special laws means that the police may have additional powers. They may have a lengthy period of time in order to investigate because of the nature of the alleged offense against the suspects.
I just want to share our experience in dealing with POTA, because we've been on a POTA roadshow throughout the country, almost in every state. And when we looked back, and one of the major criticisms that we've had of POTA is unnecessary, because we do have sufficient counter-terrorism laws in Part 6 and 6A. The predicate offences are there. And one of the arguments that we have made against POTA is if you need predicate offences, that's fine. You may need to upgrade your offences to deal with the threat of terrorism. What you can't have is POTA, because it allows for detention without trial. And that's the same argument we would use again for procedural laws. If you're looking at predicate offences, those are found in the penal code, you may need procedural laws. You may need procedural laws that are perhaps not found today to deal with the special threat of terrorism. Whether it's in detection, investigation, surveillance, you may need that. But what's critical for the bar is this. At every stage of those laws, there must be safeguards. And that is, in terms of SOSMA, that's one of our major criticisms of SOSMA. The safeguards are absent. You cannot have decisions on questions of, for example, extension from the initial 24 hours to 28 hours being made by the executive, in a sense, it's the police. You can't have that. There must be judicial scrutiny. There must be an independent arbiter who looks at the facts and says, well, in this case, yes, in this case, no. And even within the 28 days, we agreed to, we looked at it and we said, all right, other jurisdictions have 28 days. Sunset clause, it should be reduced after 5 years, if not sooner. But really, even within the 28 days, our primary argument, I remember when we were looking at the proposed amendments to SOSMA, was that should be actually, in a way, treated in installments, truncated or punctuated, if you like. So within 14 days or so, the detention and detaining authorities, the police, must produce the person before a judicial arbiter, before a judge, and make out a case for a further extension. Now, that serves the purpose of judicial oversight. So the person who's investigating is really investigating. And he's showing that he has done so much and he needs more time to complete the investigation. We cannot have, as we have in many cases, where a person is detained and there's really no investigation until the 26th day. So what happens for the first 26 days? We can't have that. And whether or not there's record of what has been done, whether there is a diary that is kept by the police and it's produced in this punctuated 14 days to show, well, in the 14 days, this is what we have done. But unfortunately, we're dealing with terrorism. It's quite complex. There's a need for evidence from all over, just not within the jurisdiction. We need more time. And this is how we propose to use the extension we are seeking, which is a further 14 days. That is needed. That's the kind of safeguards you want. Then there is somebody else who's looking at the entire process and being satisfied that the process is not being abused, that the person who is under detention is not being victimized. And what is being done is a genuine investigation by the authorities to the best of their ability.
That, although we can say that SOSMA and other preventive law are draconian, but somehow we can see that threat of terrorism is so imminent. But we'll see, like, based on the experience, dealing with those people being arrested under SOSMA and being detained, like, within that 28 days, because of the abuse of power by the police who investigated them and interrogate them for the course of investigation. So all the confession made is not made voluntarily, which is really against the law. And like, for instance, there's one case that I've represented this couple, it's a husband and wife. They purchased a ticket to Istanbul together with other family members and nephew and nieces, including like small kids, for a holiday trip. But before they went to Istanbul, they they met this some guys who talk about ISIS, about Syria, and because of that, the husband and wife and the rest of the group been arrested 2 days before departure. And during the 28 days, she was heavily interrogated together with the husband and been threatened that if you not confess to to those allegations, you will not allowed to see your kids, and then you will be you won't be released. You'll be detained here forever. So my client confessed, and then both of them were brought back. The police so happy with the with the confession, and then they provide all the basic facilities to this to the couple, toothbrush and soap, and allow them to to shower, and brought them home. So they are so happy to see the kids, but then the purpose of bringing back for the police to brought them to their home is just for the purpose of search. And then after the search has been done, the police brought back them to the detention, and then they were baffled and asked the police, "So you promised me that you will will be released. I already confessed to to your allegation." But then the police just laughed at them. And this is only one of the the cases. There's so many abuse of process has been done. Of course, we can say that we need different measure of safeguard for terrorism offences. But when it comes to abuse of process, so I can say that everybody have have a right of equality under the law. So as Mr. Amir said, we already have adequate law. We have CPC. So everybody should have a right for fair trial.
My name is Erina. My question is not specifically directing to any one of you. And my question is, are lawyers needed for SOSMA trial since the role of lawyers in such cases are limited and the judges and prosecution seem to have wide powers?
The question is related to SOSMA, in that, coming back to the same case of Khairuddin and Taisha, I think Khairuddin when he was arrested, there was confusion over what he was being arrested to and how does it apply within the ambit of SOSMA. And at one point, I think the Deputy IGP said that because it was an act detrimental to parliamentary democracy, he did use that, I think under Section 124C of the Penal Code, and that SOSMA does cover that procedurally. I'm wondering, how does SOSMA cover all acts considered detrimental to parliamentary democracy? Because the Deputy Prime Minister, Zahid Hamidi, has talked about a lot of things being detrimental to parliamentary democracy. And on that note, I just want to find out if you bring a charge against the Prime Minister, is that detrimental to parliamentary democracy, and is it applicable under SOSMA?
From the bar, my question is specifically to Tan Sri. Now, the SOSMA offers a different rule of trial, in a trial court, as opposed to a normal CPC kind of rule of trial. So, these SOSMA special rules of trial violates all the fundamental human rights. So, my question is, in your view, is it okay to violate those human rights, those fundamental human rights, just because a person is suspected to be a terrorist? Thank you.
Well, and the issue is very simple. You look at Article 149. It says, to the exclusion of Article 5, 9, 10, and so on. Okay, when such situation occurs, but the rule of thumb is this: what is that situation? It would indicate that the threat is ongoing, and something has been done, and the threat is very, very, shall I say, it must be of such a nature that you need these particular laws to address it. Otherwise, you will not be able to address. Let me give you an example. like the attack in Lahadatu, if you were going to apply the ordinary laws, it will not work. Let me put it this way. Nobody wants even to go down there to collect evidence while the shooting is going on. Who is going to collect the evidence? Who is going to record statements? Okay? That is how bad it can be. So those are the kind of situations I would think, apart from other things too. Now, you must also remember this. Your enforcement agencies are only as good as what they can perform. And they must be given the authorities and certain powers to do their work. But again, if you were to ask me, by the end of the day, you ask any lawyers for that matter, even an arrest, they will say no. Why do you need to arrest? You investigate first and charge the person. But why was everybody accepting that 24 hours? Strictly speaking, that 24 hours detention is also denying you of your freedom. But that is acceptable. Why? Then we saw the white-collar crimes. I've always said this. White-collar crimes, investigate first before you arrest. Do not arrest. Okay? But what is the distinction between white-collar crimes and other kind of crimes? Theft, for that matter. And to the victim, if you don't arrest the person, I can tell you, the victims will also raise hue and cry. But in answer to your question directly, if the laws, the federal constitution provides for that exemptions in such situations, then it can be provided. I have no views about what is fair or not. My views of what is fair is in accordance with the federal constitution and the laws. And if the law is not fair, is contrary to the constitution, then it becomes an unfair law. It's very simple. By the end of the day, the Bible is the constitution. You have to read 6 and 6a carefully. And normally, if you look at the part, it's offenses against the state, not against individual. Okay? So you look at the penal code, it's very nicely crafted, you know. It's offenses against state, offenses against person, and then injuries, property. So you can see this and what it's for. I think I'm very clear on that. Thank you.
That particular offence that you mentioned falls within the chapters which have been classified as security offences under SOSMA. So whether you like it or not, because of the wordings of SOSMA, you have Section 2, you have Section 3 of SOSMA, says that if the offences are those offences which have been set out in the first schedule, then SOSMA will be applicable. So that's how the investigation will be conducted under SOSMA, as well as the trial process as well, if it falls within one of those offences which have been defined as security offences. Well, of course, I mean, we can always argue whether or not there should be a discretion conferred to the court to decide whether this can really, SOSMA should be applicable or otherwise, depending on the factuality of a particular case. That is a different issue. That's something which is open to debate and discussion. Now, somebody did ask about the role of lawyer. I think regardless of whether SOSMA is draconian or otherwise, whether it is fair, I think when it comes to trial, when someone's liberty is at stake, I always believe that a person has the right to be represented. And if we feel that SOSMA should not be applicable in a particular trial, then a lawyer is the only person who is qualified and capable of ventilating or arguing to the court that why this act is unconstitutional or otherwise. I mean, a layperson will not be able to argue that. A layperson will not be able to understand what is Article 149. A layperson will not know what exactly is a preamble. So no matter how you view a particular piece of legislation, even ISA for that matter, I mean, a lot of people are against ISA. But then again, are we saying that therefore those who have been detained under ISA should file habeas corpus by themselves, or do they need a lawyer? So this is a situation where we don't have a choice. When the law or the procedure is fair, you have lawyer. But when the situation is far worse than what we normally expect, of course, that's where lawyers are needed more so. So when there's SOSMA, whether we like it or not, I think lawyers' role are still required to represent those who are being charged for security offences.
To be fair, to all parties. The Attorney General's Chambers, together with the bar, had this going on, what we call the Yayasan Bantuan Guaman, which YBGK, which we believe, both sides believe, that everybody should be represented. So at this moment of time, we had, I think we have all the Malaysians, anybody arrested to be represented. And also, I think we extended it to children of foreigners. Yeah. We have extended to that until I left the office. But that shows the concern by both the government and the Majlis Peguam on this representation. But remember this, the difference with SOSMA and ISA, there was like, they can try to take you in, they didn't even allow the lawyers, but in this SOSMA, within, I think, 48 hours, they must allow a lawyer to be there. It's 48 hours. So it's not as if the arrested person is not going to see a lawyer. He has the right. Thank you.
If you recall, he initially was detained under 124C, activity detrimental to parliamentary democracy. Initial 24 hours.
Attempt.
No, initially was not. It was that. Attempt. I think it's B, 124B then. And after the initial 24 hours, I can't remember, they had got an extension, or was it 7 days, Hanif? 7 days? 6 days. 6 days. All right. Within the 6 days, they decided that he was not in any way involved in any activity detrimental to parliamentary democracy, and they decided to release him. But at the point of release, suddenly, it shifted to SOSMA. That's when it became the sabotage, and then in the case of Matthias, the attempt to sabotage. So it was a shifting. So it's very confusing. I think that's the problem, and it's the point that we took. You cannot be moving first from a detention under the CPC for one offence, and when you can't prove that offence, you suddenly move into other two offences and then invoke SOSMA. You know, CPC and SOSMA don't follow like night follow day. You know, you have to decide. All right, and that's what happened in this in Dato Sri Khairuddin's case.
This is directed to Tan Sri. Considering the fact that POCA, POTA, and SOSMA has been used together to counter terrorism in Malaysia, from the Asia's Chamber perspective, is it necessary? From your opinion just now, I think you made it quite clear that the SOSMA is a very good legislation on its own. If so, why do we need POTA and why do we need POCA to handle terrorism? The second question is, if you look at the recent case of Adnan Farizi, the alleged IS hacker, it will say that the public prosecutor requested for his arrest because there was an extradition order by the US government. But he was arrested under SOSMA. Procedurally, is that acceptable?
First of all, as a professional, I cannot comment on something that I do not know the details. I wouldn't be able to. And to make comments when I do not know the facts of the case, exactly what went on, would be wrong. However, on the first issue you raised, okay, whether they needed or not. Let me put it this way: the applications of those laws, detention for investigation, are not within our purview. That is for the enforcement agencies to decide. We don't cross over to investigate. That is not of our business. They will have to put their mind as to what is fair or not and apply those laws. And that is their duty. By the end of the day, what was the safeguard? Remember just now I mentioned, before the 28 days expire, they must refer to the public prosecutor. Then the public prosecutor, that is the safeguard. Only then it comes in. Otherwise, no public prosecutor has the right to disturb any investigations. None, as far as I'm concerned, during my time. Okay? It has to be done that way. There has to be separation of powers. Thank you.
Ken Chua, I'm, Tan Sri described me as a lawmaker, as if like SOSMA, it was my responsibility. First of all, I would like to thank and congratulate Tan Sri because when legal institutions fail to protect individuals' rights or fail to protect, safeguard people's rights. The only discourse is activism, the way of people speaking out against abuses. So I'm very glad that today Tan Sri speak out in front of all of us against the abuse, and this is one of the ways to safeguard. But I would like to also make questions to him that just now he mentioned it as if like we are the one who make law and Tan Sri just execute the law. But everyone who know this country know the reality is his office make the law, submitted to the chamber in parliament, and as oppositions, we have no chance to amend even one titik comma or full stops of the law. So, and clearly, as Khairuddin's and Matthias Cheng case show that the law has defect and it's allowed the executive to abuse it. I would like to know if Tan Sri have a chance to rewrite the law again, whether there will be more safeguards built into it. And as we were debating, we make it clearly that we agree with the Bar Council. The law has a lot of defects. The law allowed the executive to abuse. Despite the Prime Minister's guarantee, we said the same thing. It was just like the ISA. It was guaranteed that it was only used for subversive, but at the end, he used it. And it is so fast, within such a short time, we have seen the abuses. So I'd like to hear from Tan Sri about his possible amendment to the law.
I will say this to you, with respect, of course. In the first place, I've always prided myself to be neither a politician nor a diplomat. I call a spade a spade. In the first place, I've never said exactly that, oh, these are abuse. Yes, I didn't. Remember what I said. Until I know the facts in detail, only will I make comments. That has been my job all the while. And to prove abuses, you all know that it has to go beyond reasonable doubt. As a professional, no matter what you are, lawyer or in the prosecution, you hold by that principle alone. Otherwise, you are of no use. Otherwise, you fall within the category of others I will not mention. On the whether I will amend the SOSMA or not, let me tell you the processes of how laws are drafted. Yes, the AG's chambers will draft the laws, but these are all promoted by the various agencies. If the Attorney General's office do not simply put up laws on their own, no. And what is the other process? It goes on. After that it has been drafted, they discuss with all the various agencies. Everything has been put up together. This paper will be put up to the cabinet for approval by the minister himself. So the minister will put up to the cabinet, that will be approved, and then it will be sent to the parliament. And yes, maybe, I'm not too sure who voted for or against, but by the end of the day, it is Parliament who pass it. I think that is the issue. I will not cast aspersions to you, YB. At the same time, whether you voted or not, I will not say what. I do not know, actually. I do not know. All I know is that Parliament passed it. But I cannot say, oh, Mr. So-and-so voted against it or voted for it. I can't say that. But what I can say that is, I admit, generally, I think in these kind of laws, the opposition will not support. Is that fair enough? Thank you.
My name is Shaharuddin. I'm a law practitioner in Selangor. I wish to address this question to either Ame or Stephen. Now, I think tonight we have made more than, we have made out a case, more than a preponderance of probability that possibly SOSMA might be unconstitutional. Now, my question is this. Granted that we have a decision, the Robert Lingi case in Sabah, there was a High Court decision that completely changed the landmark of locus standi in Malaysia. And subsequent to that case, we've got, of course, the case of Uttaya Kumar and Manoharan, that is a Court of Appeal case approving the Sabah Robert Linggis case that completely obliterated the ruling of the powerful panel of the House of Lords in the case of Goret versus Postal Workers Union, I believe. It changes also the test of locus standi in Lim Kit Siang versus Government of Malaysia in the 80s. That is to say, today, Malaysia has the most flexible local standi test anywhere in the Commonwealth, if you look at it. So the question is very simple. Granted this new judicial activism, refusing to follow even English rule on locus standi, that is to say, anyone can come forward to the courts by saying that a particular law is against the Constitution, and that is good enough. The question that was formerly not allowed by the courts, if it is not this man, who else can sue? That apparently has been the order of the day. The judge can ask, if not this man, if not this plaintiff, who else can sue the government? Now, the question is this. Can we expect soon that the Bar Council or anyone in this room or any NGO will mount a challenge on the constitutionality of SOSMA? That's the question.
My name is Jackson from ITC. My question is to Tan Sri. Since the AGC is the person, is the people in charge in drafting the law and put forward to Parliament as recommendation, I think Tan Sri is the best person to answer my question. My question is fairly simple. Is there really a need to bypass the judiciary for the extension of detention for 28 days? If there is a need, how can it be justified? And secondly, is there really a need to deny the right to an attorney for the first 24 or 48 hours? I'm not very sure. Not very clear on it. If there is so, is there really a need?
When 48 hours is given to you, to an enforcement agency, it doesn't mean that he has exhausted 48 hours for all cases. No. There are some cases within 6 hours or 24 hours they can do it. They will give recourse to an attorney. But in some cases where they need to travel or whatever the distances and all that, possibly they need to reflect. That's why they need the 48 hours. So depending on that, and they will have to justify that. Okay? And the 28 days also, not reference to there are possibly the investigations especially on serious matters like ICs and so on, where they develop into cells. The issues is that the operations of, I'm not an expert on this, but from what little I know, I can tell you, but I can't tell you everything. But the operations of ICC is entirely different nowadays. It goes in cells. In those days, you arrest one, you will possibly get all the others. Today, you can't. That's the difficulties. There's a lot of difficulties. You have to be fair. After all, it's your own security. Thank you very much.
Question posed by Shah just now, with regard to whether there will be any challenge on the constitutionality of SOSMA. I cannot speak on behalf of the Bar Council because I'm not a member of the Bar Council. But as far as the cases that I'm currently handling, yes, I mean, that is one of the issues which had been argued and will be argued again. So yes, I mean, and I believe the council, Hanif Khatri is here, he's representing Matthias Chang as well as Datuk Sri Khairuddin. I'm sure he has also in a way, I mean, formulate some sort of arguments to challenge the validity and the constitutionality of the act itself. I think it goes without saying that lawyers, whenever you have the opportunity, you will try to put all possible arguments in order to protect the interests of your client, factually as well as legally. So I think, yes, I mean, the question is whether or not someone will challenge it, definitely. I mean, if you're representing someone who's been charged for security offences and SOSMA is the applicable law, you will definitely challenge that particular provision of the law.
Shah, I'm not totally with you when you say our rules of locus standi has been so liberalised to the point where we are in the forefront of the Commonwealth. I don't think so, because the MTUC and Shabazz decision of the Federal Court did not really say much more than what we already know, that is that you must show that you're adversely affected in a particular way. And that still presents a problem. But in terms of challenging any law, whether it's constitutional, we may well draw on the LPA itself under Section 42. It's not something that we have really pushed on, but it's something that we can if you wanted to. So you don't really need to fall back on the common law principles in those cases. On adversely affected, the statutory standing may well be enough.
Okay, my name is Liao. I'm a practicing solicitor. And my question here is directed to Tan Sri Patel. Now, he did hint earlier that there are other legislation which, or let's put it this way, I'm putting it this way. The interest of the bar has been lately arisen because one of our members is actually detained under SOCMA. So SOCMA has come into the limelight. I don't think I'm going to ask Tan Sri about the constitutionality of SOCMA, whether it is exceeding or Section 149, is it? 147 or 149 of the Constitution, Article 147 or 79. But in the case of, I would think that overwhelmingly members of the bar will knows that this is a wrongful application of SOCMA. All right? In the case of the lawyer which is under detention, and I think Mr. Khairuddin, who is his client, Tan Sri referred earlier to a Whistleblowers Act of 2010. All right? It is something which is given a wide berth to whistleblowers, to people, to expose corruption, because corruption is a very insidious and is naturally a conspiracy.
Mr. Liao,
you do not have...
can you please get to the question? I'm so sorry.
Yes. So my question is, when it's obvious that it's a wrongful application of an act, can we say safely that we can leave it to the wisdom of our judiciary to throw out this charge?
Okay, thank you.
Yes, you have to depend on the judiciary for redresses of any grievances. That is a fact. Okay? Because in the final recourse, you go to the judiciary. Now, on the issue of whether he was charged, I think what you're after is basically this, whether I feel that he has been charged properly or not, whether there is a case against him or not. Again, I have to tell you, I cannot, because I do not know the facts. The only thing I know is that he is a lawyer and he has been remanded or detained under that particular law. That is all I know. And he is a lawyer and, of course, allegedly representing the other person. That's all. Further than that, I do not know what the prosecution have. And you have to be fair to them. That has not been disclosed as yet. We have to look at the trial. If at the trial there was no evidence, nothing, then that is bad prosecution. But if they have something else to prove, yes. A lawyer is not exempt. Even the Attorney General is not exempt. Even ex-Attorney General is not exempt from the laws. That is what it is. Okay? So I hope I've answered you. I thank you very much for your concern.
Okay,